All right, folks, we've got William H. Murray with us today, and we're going to be talking about PATCO. Bill, go ahead, take it away.
On July 3rd, 2012, the United States Court of Appeals, First Circuit, returned a decision in the appeal of PATCO Construction Company, Inc., plaintiff, appellant, the customer, versus People's United Bank, doing business as Ocean Bank, defendant, appellee, the bank. This decision reversed material findings of the lower court and remanded the case to the lower court for processing. Specifically, the appeals court reversed the summary judgment granted to Ocean Bank. It found that this order relied upon a finding that the security offered by Ocean Bank was, quote, commercially reasonable, unquote, a finding which the appeals court rejected. This is an important decision. It brings this case into agreement with the decision in Experimentals versus Comerica, a case based upon similar facts and law, in which the court held for the plaintiff. It reduces the probability that the Supreme Court would grant a petition for certiorari for a further appeal. It upholds the provisions of Article 4A of the Uniform Commercial Code, which governs the rights, duties, and liabilities of banks in commercial wire transfer. The default under this provision is that if the transaction is not authorized, the bank stands the loss. This is also consistent with the bank's common law responsibility to ensure that transactions are authorized. When I read this verdict, when I read that this verdict had been reversed, I went back to my blog to review what I had written on the case. Most of what I wrote stands up pretty well after a year and in light of the verdict on appeal. The exception was my expressed hope that the case not be appealed. I was concerned that it might accept as fact the finding of the lower court that the security procedures were commercially reasonable and thereby establish a bad precedent. Mark Patterson, co-owner of PATCO, thought better of it, did appeal, and was vindicated. Fortunately for all, the appeals court revisited that question as a matter of law. Patterson struck a powerful blow for small and mid-sized businesses and their asymmetric relationship with their banks. He says, it's great news for victims out there who are going after their banks that have not been keeping their customers' money secure. It's a wake-up call. Kudos to Mr. Patterson. I continue to be impressed with the ability of the courts to sort out these very complicated issues. This decision is informative, instructive, and easy to read. Even if one were to dispute it, the decision sets forth a clear record of both facts and law for our consideration, discussion, and enlightenment. I commend it to all bankers, small to medium businesses and municipalities, information assurance professionals, and those engaged in computer forensics. One need not be a lawyer or a security professional to appreciate this decision. The facts documented in and relied upon by the decision describe the security options available to Ocean Bank in NetTeller, the e-banking application software from Jack Henry Associates that Ocean Bank was using. I won't go through the list of all these things that were included, but I will say that Ocean Bank implemented more than half of the features. But there was a problem with those that they chose not to implement. They didn't implement the user-selected image, a shared secret intended to help the customer distinguish between the bank system and a spoof of it before exposing his credentials. This feature is sufficiently widely used by other banks that false bank sites are not a preferred attack. However, they also fail to implement the measures most effective against the favored attack, credential replay, i.e. out-of-band or one-time password authentication, and transaction risk scoring and monitoring. One of these features they misused. The challenge court agreed with the testimony of an expert witness that by lowering the transaction threshold for invoking challenge response from only those transactions above $1,000 to all transactions above $1, the bank increased the probability that the responses would be compromised and thereby weakened the system. After PATCO became a customer, Ocean Bank offered out-of-band, that is email, alerts of all activity on an opt-in basis. PATCO claims that it was unaware of the offer and did not opt in. I would argue that out-of-band alerts and confirmations are so efficient that they should be on by default. If the customer is being overwhelmed by confirmations, he can set up a filter. Other facts not in dispute include that PATCO hired an IT consultant who ran a malware scan against the machine in question. The scanner, which was intended for remedial rather than forensic use, contaminated the machine and destroyed some evidence. I hope that none of my audience would have made such gross errors as hiring someone unqualified to do forensic work or failing to conserve evidence. The court accepted expert testimony that at the time in question, keylogger malware was a persistent problem throughout the financial industry. Therefore, the risk that user ID, password, and challenge responses would all be simultaneously captured was foreseeable. That was the basis on which the court overturned the summary judgment. As a result of this decision, we now know some things with confidence, approaching certainty, that were in question after the original decision. These include, in electronic wire transfer, risk for unauthorized transactions lies primarily with the bank, not the customer. The burden of proof is on the bank, not the customer. The requirement of the UCC that security be commercially reasonable trumps the Federal Financial Institution Examination Council, the FFIEC, authentication guidance. Literal compliance with the guidance may not be commercially reasonable. We now know commercially reasonable is a higher threshold than previously thought, higher than the banks have pretended. The court heard testimony on the pervasiveness of keyloggers and concluded that the risk of credential replay is, quote, foreseeable, unquote. Therefore, by default, strong authentication to resist such replay is indicated. However, such authentication is not enough. In determining whether or not a transaction is authorized, and again, by default, banks must look beyond the credentials accompanying it to whether the transaction is reasonable for the customer in question. Some things are still in doubt, and some questions still open. For example, we think we know that there was a keylogger on the PATCO machine. However, because PATCO's agent corrupted the machine, we'll never know for certain, to a certainty. The record is not clear as to whether alerts were offered or accepted. Finally, and most importantly, we still do not know what obligations, if any, PATCO had if the security offered by the bank is commercially unreasonable. Under Article 4A, there is an alternate to commercially reasonable security as a means for the bank to shift some or all of the liability to the customer. Only the first question was actually litigated in PATCO versus the first option was litigated in PATCO versus Ocean Bank. The second, authorization by means of an agreed upon security procedure, read contract, was not reached or considered by the lower court. Under the remand, this question may arise. There is a difference between PATCO and the bank as to whether there was such an agreement, what it called for, and whether or not PATCO met its responsibility under such an agreement. The appeals court has urged the parties to settle this without further litigation, so we may never know the answers to those questions. The advice that we must, as information assurance and professional and forensic professionals, give our principals must reflect this decision. This is not rocket science. NetTeller and other commercial off-the-shelf software offer both strong authentication options and software for scoring the risk of a transaction. We should make it clear to our business clients that while the bank must take the risk for an unauthorized transaction, the bank is not responsible for consequential damages. Moreover, the bank will try to transfer this fundamental responsibility to them by means of contract. They should choose their banks carefully, ensure that the bank offers commercially reasonable security, understand and comply with their agreement with the bank. Specifically, they should reconcile their accounts in a timely manner and reconcile variances promptly. By default, in this case, timely equates to at least daily. Finally, they must resist compromise of their systems and credentials. I use my iPad for e-banking and recommend to my clients that they use a dedicated and locked down system for e-banking. It should be clear from the facts and findings in this case that both the bank and the customer, both acting in good faith, did counterproductive, not to say stupid things. Neither our bank or our small business clients are experts in security. Left only to their own resources, they are vulnerable to costly, not to say fatal errors. They are dependent upon us. We owe them diligence and competence if we are to be called professionals and be paid the big bucks. See you next week.
Okay, Bill. That was it's a pretty darn good review of PATCO. Thanks for that. We certainly do appreciate it, and let's hope we can go on to better days where these lessons are put to use.
Yeah, neither PATCO nor Ocean Bank were well served by their security people. And we've got to do a better job. We can't continue to leave our clients hanging out the way these two clients were.
Yeah, well, that goes to a lot of things you've been talking about in these editorials, and that's more professionalization of this industry to begin with, especially on the security and risk end. All right, it's a big deal, and it's a giant conversation that you and I both know is swirling round and round and round every single day of the week. All right, good one. We'll talk to you soon.
Okay,
Right.
bye.
Bye. All right, everybody. William H. Murray, the INFRAGARD editorial, and we're doing well there as well.
It's
right?
10 o'clock.
Up those mic levels just a little bit. Okay. Okay. Hopefully, you can hear me a little bit better now. And now I'm not getting anything online too at all. Something's going on. All right. Well, that's